Order. My name is Laura Alarcon. I'm Chief of the California Bureau of Security Investigative Services. I want to note that the meeting today is going to be conducted in accordance with the agenda as noticed, with the exception that item 9, discussion regarding alarm agents, locksmith employees, security guards, and proprietary security officers must be employees and not independent contractors, is being removed from today's agenda due to the Bureau staff not having completed all the needed research to present this item today. Additionally, if, because of time issues or time factors, by approval of the committee, another item could be taken out of order if necessary. I also want to note that this meeting is being webcast on the internet, and the webcast can be accessed via the BSIS homepage at bsis.ca.gov. And please note that due to circumstances beyond the committee's control, there could be parts of the webcast that is preempted. It hasn't happened today, highly unlikely, but I just want to let you know that that is potential. So I want to start now with item 2, introduction and swearing in of advisory committee member Frank Huntington. Mr. Huntington has been appointed to the private investigator industry position. Mr. Huntington has over 27 years of experience in the private investigative industry. He's also served as the director of the Sacramento District for California Association of Licensed Investigators, otherwise known as CALI, for the past 7 years, and he currently serves as the chairman of CALI. With us today to swear Mr. Huntington in is the director of the department, Dean Graffilo, and he will be administering the oath. And Mr. Graffilo, are you ready? Thank you. Please join me in congratulating Mr. Huntington and welcoming him to the committee. We'll take a minute for a couple of signatures to be completed, and then I'll ask for the roll to be called. Item 3, please call the roll.
BSIS Advisory Committee roll call for January 11th, 2018. Simon Cruz.
Here.
Simon Cruz here. Marcel Egley. Marcel Egley here. Anton Farmby. Frank Huntington.
Here.
Frank Huntington here. Todd Inglis.
Here.
Todd Inglis here. Matthew Lujan.
Here.
Matthew Lujan here. Lynn Morfeld. Nancy Murish.
Here.
Nancy Murish here. Eli Owen. Eli Owen here. Stanton Perez.
Here.
Stanton Perez here. Roy Ron.
Here.
Roy Ron here. Tim Westphal.
Here.
Tim Westphal here. 10 members present. We have quorum.
Thank you. For the record, the official start of the time, official meeting start time is 10:05. I would like to now take a minute to stand up and say the Pledge of Allegiance. So we're now on item 4, review and approval of the minutes for the July 13, 2017 meeting. Do I have a motion to adopt the meeting minutes? Do I have a second?
Second.
Okay, now do I have any questions from any of the committee members regarding anything that was noted on the meeting minutes? Clarifications that are required? Any questions regarding any of the comments that were had? Seeing none, any comments from the public regarding the meeting minutes of the July 13 meeting? Seeing none, please call the roll.
Motion to approve July 13th meeting minutes. Simon Cruz.
Aye.
Simon Cruz, aye. Marcel Egley.
Aye.
Marcel Egley, aye. Anton Farnby. Frank Huntington.
Aye.
Frank Huntington, aye. Todd Inglis.
Aye.
Todd Inglis, aye. Matthew Lujan.
Aye.
Matthew Lujan, aye. Lynn Morfeld. Nancy Murish.
Aye.
Nancy Murish, aye. Eli Owen.
Aye.
Eli Owen, aye. Stanton Perez.
Aye.
Stanton Perez, aye. Roy Ron.
Aye.
Roy Ron, aye. Tim Westfall.
Aye.
Tim Westfall, aye. 10 ayes, the motion passes.
Motion's adopted by a vote of 10 to 0. So that takes us to item 5, the Bureau Chief's welcome remarks and any news and updates relating to the Bureau. It's housekeeping. The agenda is in, and as well as the handouts that are going to be associated with today's meeting are in the back of the room. I want to have Bureau staff here present today to introduce themselves. And prior to doing that, I'd like to let you know that the Bureau's counsel, Sheila Barker, had a scheduling conflict today, and in her stay today assisting us, and thank you, is Supervising Counsel Anthony Payne. Morning, everyone. So members here from the Bureau, please introduce yourselves. So, I'd like to note for the record that Anton Farnsby has just stepped into the meeting. So he arrived for the time 10:08. Where is? Welcome, Mr. Farnsby. So, I want to begin with the updates. We're talking about licensing update. So from July 1st, 2017 to December 31st, 2017, which is the first 6 months of the fiscal year 16-17, the BSIS received over 35,000 initial applications for licensure and about 44,600 applications for renewal. This equates to an average about 5,800 initial applications being received each month and about 7,400 renewal applications being received. Approximately 82% of the security guard initial applications and 55% of the security guard renewals were on Breeze. So these rates are now aligning with the prior licensing system that existed before Breeze. Breeze launched in January of 2016, the online professional licensing system. So it's very good. Initially, upon onset, we did see a dip in online apps, which really does impact the Bureau's workload because those online applications really assist us significantly, and it's great to see that the rate is now back up to what it was before Breeze. With the exception of alarm agents, the Breeze participation rate for the other license types have been comparable to the information that I've shared with you in the past since the Breeze launch. Overall, Breeze rates for other license types, however, are nowhere near the security guard rate. We're seeing slow increases with the exception of alarm agents, which I think Tim's going to be very excited to hear this. We've just seen very low growth. However, during the July meeting, I noted that the application rate for alarm agents on Breeze was at 28% for initial applications and 39%. That was for the last fiscal year. I'm happy to share that from July 1 to present, that participation rate at initial application for alarm agents is now 62%. So, I mean, that is a significant increase. And I know that the California Alarm Association has been very proactive in getting the word out, and those efforts are very much appreciated. Obviously, you did a good job, so thank you. And as far as the renewal rates, those also went up 10% from where they were last time. So, from July 1, 2017 to December 31st, of the nearly to put those numbers in perspective, of nearly 2,000 of the ACE apps that came in, half of them were on Breeze. So in regards to the locksmith employees, they stayed fairly consistent from the last year, where 60%, which is still a very great number, of initial employee apps were coming on Breeze, and 32% in renewals. Proprietary security officers, again, very similar to data reported last time, 42% on Breeze for initial applications and 52% on renewal. Repossession agents, due to the nature of the license, the association of the employee registration with the company license, do not have access to Breeze for initial licensure. But on the renewal basis, we're running about 40%, which is comparable to last time. While the benefits of Breeze are not significant for non-registration initial applications, there are significant benefits for company licensees and qualified manager certificate holders, as well as firearm and baton training instructor certificate holders to renew on Breeze. So for private patrol operator companies, we basically stayed at the same ratio that we had 6 months ago, which is 20% at initial and about 30% at renewal. Alarm companies, a little bit disappointed. We dropped from the last time about 33% being on Breeze down to 13% for initial applications. So it seems like we had a shift between alarm agents and the companies. So whatever you did for the agents, let's see what we can do and work together on seeing what we can do now to get more word out on the companies. So as far as the alarm company qualified manager, those rates are staying pretty consistent at 40% for both initial and renewal. Locksmith employees, we're staying about the same rate of 30% on initial and renewal. Repossession agencies, we're doing pretty good because about half the applications coming in are coming in on a Breeze for initial. And for renewals, that drops down a little bit more to 40%. Repo 8 qualified managers, Marcel, I think we're going to need to work with CalR. We received no applications during the 6-month period on Breeze from a qualified manager. So we need to kind of work with the association to find out potentially what obstacles your industry folks may be seeing and what we might be able to work with them to get them to be involved a little bit more with the Breeze on the initial. So while they're not coming in at initial, over half are using it for renewal. So we got to talk to you a little bit more, finding out what's going on that initial app. Training facilities as it relates to batons, I have 0 for initial applications, but in all honesty, those application numbers are low overall, so not having a significant one come in is not alarming. But again, I still think it warrants us to have a little bit of discussion if maybe from the facilities perspectives, you're seeing some things that we might be able to enhance to get more participation. On the firearm facility, we're seeing about a third coming in on firearm for initial and about half on renewals. And the training instructors, pretty much comparable, about a third and half for initial and renewal. So the benefits of Breeze, most notably, is overall in general, applications are going to move through the processing times much more timely. So again, we want to make sure people are aware of Breeze. We want to have that dialogue to find out potentially what things we can do more to get the word out on the benefits of Breeze. Clearly, the interaction that we had with California Alarm Association and the alarm agents worked. We saw, more than 2.5 increase. So we want to see what we can do in the other industries as well to get that type of push as well. So the other thing I want to talk about regarding licensing activities is that in September of 2017, the firearm permit applications for both initial and renewal were removed for Breeze. So this is a little bit unique in the sense of all the other applications were touting, get on Breeze, get on Breeze, get on Breeze. And yet, Bureau Management, we met several times. We've made changes to the application information that's on Breeze. We've worked with CalSAGA, getting the word out about that when you submit a firearm application, it's not just completing the data points in Breeze, it's also scanning and attaching an actual copy of the firearm permit application. And the reason that application needs to be attached is because the firearm application is unique in that it not only requires the applicant's attestation, but it requires the attestation of the firearm instructor to attest to the fact that the individual, one, completed the training for the firearm permit, additionally scores that relate to the range and scores that relate to the written exam. So in spite of multiple efforts to see what we could do to get the message out there that just completing the Breeze form and submitting payment did not constitute an application, we could not drop the deficiency rate below 50%. So 1 and 2 of the firearm permit applications were coming in without the scanned document. We changed verbiage, we messaged, it just wasn't coming down. And unfortunately, when we have that high of a deficiency rate, as was noted in the Bureau's audit when we were looking before the fees, that creates a huge workload on the Bureau, which creates backlogs. So we finally made the decision to remove in September of 2017 firearm permit applications from Breeze. And the only means by which both the initial and the renewal firearm permit can be submitted is in a paper format. The other thing that seems to have an issue with firearm permit renewals that creates a very significant deficiency is that the law is very unique for the firearm permit renewal process. The way the law is written is that once that firearm permit expires, on the date it expires, there is no grace period for delinquency renewal. If it's not renewed prior to expiration, it cannot be renewed, and the individual has to seek another new initial pursue another initial firearm permit application if they want to continue holding the firearm permit. The other thing that seems to be one of the highest deficiencies that one of the significant factors in increasing our workload, and for you in the facilities and the employers, private patrol operator representatives here, CalSAGA, if you can really try to get the word out for the firearm permit holders by law, and this is now on, we've updated the firearm permit applications in this verbiage, this exact, well, the essence of the verbiage is on the application itself, both on the initial application before they even go into renewal point, as well as the renewal process, that you have to submit your renewal application at least 60 days prior to expiration. And why it needs to be submitted 60 days is that's the Bureau's processing time. And if you recall, part of the renewal of the firearm permit is also communicating with the California Department of Justice, where they have to also confirm that the individual during the time has not been deemed prohibited from possessing a firearm. So many times we get, probably more than not, we're getting firearm permits less than that 60-day window. And it's not uncommon for things to be elevated to me that the Bureau didn't renew my application on time, and when I actually start dealing and delving down into questions to the applicant, they submitted that renewal 3 days before expiration, 1 day before expiration. I mean, the Bureau is not able to get something turned around in 1 day with the workload that we have. And basically, as I shared earlier, we're talking over 6,000 applications a month and 15 employees in, total in the licensing unit. So it's very important for firearm permit holders to know you've got to get that application to us as prescribed by law at least 60 days before expiration. So we updated the apps, and this was also the firearm permit apps, which was part of our overall efforts and the commitments that I made when we were talking about the fee increases for the Private Security Services Fund, that the audit revealed not only the need for the fee increase because of inflation, additional mandates being imposed on the Bureau, but also operationally, we have high rates of deficiencies, and we're trying to look at things to help drop that deficiency rate. And one of the things we're starting with was the firearm permit, because as I previously noted, we had the most significant deficiency rate with this license type, was to add additional information on the firearm permit application, make things very clear. There may be times in the instructions things are said more than once, but it is all part of our efforts to enhance our efficiency and effectiveness. And so the other thing that we did was we added an actual suggested schedule. It's not mandated, but one of the things, the way the regulations are written, in order to renew a firearm permit, the permit holder has to complete firearm qualifications 4 times during the 2-year term of the license. And those four requalifications are spaced out by regulation to ensure that the individual has refresher and time, and it's not just all 4 requals jammed between 2 months before expiration. So the way the regulations are written is the individual has to complete 2 range qualifications for each 12-month cycle of the firearm permit, and no 2 range qualifications can be closer than 4 months apart. And so oftentimes permit holders were not eligible to renew the permit because they did not complete the requalifications in accordance. So now the application form, both on the initial application and the renewal applications in the instruction sections, has a suggested timetable for completing requals that if the applicant aligns with that, they're aligning with the requirements of the regulation. The other thing that we added to the firearm application was a reminder to firearm instructors on the proper scoring. And we'll be talking a little bit more about that on a later item, when we talk about updates overall that are going on with the firearms manual. But again, it was an effort of looking at what are the highest deficiencies, what are the reasons that the Bureau is having to touch an application more than one time. And a lot of it also had to do with firearm instructors not providing the required score correctly for the written exam. So that concludes my licensing update. In regards to enforcement, from July 1, 2017 to December 31st, 2017, the Bureau has conducted 92 compliance inspections, and these inspections have involved private patrol operators, firearm training facilities, alarm companies, and repossession agencies. In that same fiscal year, the Bureau received 1,569 complaints, and we opened up about 760 investigations, and approximately 660 investigations were closed. The enclosed investigation count includes those that were carried out both by enforcement staff, the Bureau's actual enforcement analysts, as well as the Department of Consumer Affairs Division of Investigation, which is the law enforcement branch with the department. One Bureau investigation I would like to note relates to a person who held an alarm company qualified manager certificate. Due to the Bureau's efforts, the certification was revoked in October through the administrative hearing process. And a key factor for the revocation was that this qualified manager had established business practices he was associated with a couple of alarm companies. And the activities that were involved entailed misrepresentation of the facts to the consumers onto which business company they were actually entering into with an alarm monitoring contract. Namely, the consumers believed they were entering into a contract with the alarm company being represented to them at the point of sale, when actually they were entering into a contract with an out-of-state alarm company that did not hold a BSIS alarm company license. So the investigation is continuing. Right now, we're associated with the qualified manager, taking action, and we're continuing to work on the companies that were involved. Bureau's complaint resolution staff resolved over 60 complaints in fiscal year 16-17. These are complaints where the Bureau staff were integral in achieving a mutually agreeable solution between the complainant, the individual who filed the complaint, and the Bureau licensee. And one CRP, or complaint resolution complaint I would like to highlight, involved a disabled homeless veteran who was living in his car, and the vehicle was repossessed with all of his possessions. Because the repossession involved a forwarding company, the individual was having difficulty finding out how to get his vehicle and how to get his possessions back. CRP staff worked with the agency and the forwarding company to identify who actually repossessed the vehicle, and we were able to have the veteran's possessions returned to him, and in fact, the storage fees waived as well because of the conflict. And so in this particular situation, the difficulties with the notice, Marcel, was that he was homeless. There was no address to send the notice. And so it was not that there was anything that was carrying on that was deemed a violation, but this individual was just kind of caught between a rock and a hard place. But complaint resolution was able to step in and get the whole issue resolved. And the repossession agency graciously worked with us once the issue was brought forth. Yeah, so you're welcome. So that concludes my update regarding additionally, in fiscal year 16-17, the Bureau referred 37 cases to the Attorney General's office, primarily to seek revocation of the license. But this also include applicants who were seeking to appeal the Bureau's denial of the Bureau's decision to deny the application for licensure, as well as appeals of citations that the Bureau issued to a licensee. Now that concludes my update on enforcement. So I want to talk next about legislation that was signed into law or was provide an update overall that impacted the Bureau and the private security industry. So the first bill that's noted on the agenda is Assembly Bill 290. This bill made permanent the exemption for dealers of agricultural and construction equipment to carry out repossession activities without holding a repossession agency license under specified conditions. It should be noted that that exemption was first established in 2013, and it was set to expire on January 1, 2018, and the legislation removed the sunset date and made the exemption permanent. So the next bill I want to talk about is Assembly Bill 1616. This bill also was signed into law, and basically it prohibits any city, county from imposing a civil penalty, a fine against an alarm company operator or an alarm agent for a false alarm if the cause of the false alarm was not attributable to the alarm company or agent improperly installing the alarm system or did not relate to a defective alarm system. The bill also specified that the Bureau is not required to investigate or adjudicate any cause of action relating to penalties imposed by the local jurisdictions against any alarm company, operator, or its employees. The next bill, Senate Bill 420, that was signed into law, clarified that criminal history information provided by the California Department of Justice to specified authorized entities is to include sentencing information if sentencing information is applicable to that applicant. The Bureau is authorized to receive by law criminal history information from DOJ on its applicants for licensure. And this bill was introduced last year in 2016. Well, it was introduced last year in response to a Department of Justice decision that was made in March of 2016 that the law under which it was operating at that time did not provide the explicit authority for the release of sentencing information. So for that period of time, the Bureau did not have sentencing information when we were looking at applications, which sometimes when we have sentencing information, it assisted us in being able to determine, how to move forward with the application. So beginning now, we'll be getting that information on applicants coming in the door. The next bill I want to talk about is Senate Bill 559. This bill made several changes to the Private Investigators Act, including it extended the sunset for private investigator licensee or license to be held by a limited liability company, and extended the sunset to January 1 of 2021. Also, effective July 1, 2018, this bill now requires every PI licensee who holds the license as a limited liability company to provide the department with information regarding the claims that have been filed and the claims that have been paid against their liability insurance policy. It will also require the Bureau to make that information public on the license search. So we're working on modifying the Breeze system so that starting from July 1 forward, if a PI is licensed as an LLC, part of the information that will be available on the public website is the number of claims that have been filed and paid against their liability insurance policy. The bill also requires the Bureau to put on the public website if a PI licensee is actually organized as a limited liability company as well. The bill also clarified that an employee of a private investigator licensee is not permitted to provide armed protective services incidental to the investigation. It clarified that the PI licensee is not subject to the provisions of the Private Security Services Act Disciplinary Review Committee regarding violations of Bureau law or regulations relating to a firearm. It also clarified the allowable hours of credit for a law degree, bachelor's degree, or associate degree that can be applied toward the years of experience required to be licensed as a private investigator, and made various other technical changes relating to the references of manager and qualified manager. And as background, in this Practice Act, as well as several other Bureau Practice Acts, there is an individual that's identified as the qualified manager. This is the individual that serves on the license or is associated with the license to ensure that that licensee is carrying out its business in accordance with the provisions of the respective Practice Act. By bringing in limited liability company license types into the Practice Act, however, the references of just manager, which oftentimes the Practice Act used manager in lieu of qualified manager, created confusion due to the changes in law that happened with limited liabilities in the Corporation Code a couple years back. Namely, now that limited liabilities can have manager member LLCs, in which case the manager could be an agent of the LLC and not necessarily the qualified manager. The next bill, SB 547, was considered an omnibus bill, which means it had multiple changes in the Business and Profession Code related to other licensed professions within the Department of Consumer Affairs. It also included changes to the Bureau. The most notable ones for the Bureau was that it establish the new fees that are going to be put into effect July 1, 2018, for those license types that support the Private Security Services Fund. So that includes, it basically includes every act that the Bureau is tasked with regulating, with the exception of the Private Investigator Act. It also revised the implementation date for the assessment that will be required for the firearm permit security guard applicant. Based on legislation that was enacted last year, the Bureau was entrusted with implementing by January 1, 2018, the new assessment program. I will be talking a little bit more specifics of what is going on with that assessment program, but for now, just to state that it became apparent additional time was needed to adopt that program, and so SB 547 modified the January 1 implementation date to basically state that the Bureau has until January 1, 2018, or on a date to be determined by the Bureau, but no later than July 1, 2018. So it basically provided for an additional 6 months to implement this new statewide program. Last bill I want to talk about is SB 800. Again, this was another omnibus bill, and it made several changes to the Business Profession Code. The ones that were notable to the Bureau was it eliminated the requirement that the expiration date on a Bureau license that is associated with a firearm permit be synchronized, the two dates, expiration dates be synchronized. And this change was needed because of the new requirement for the firearm assessment for security guards and the need for program integrity to identify a security guard if it's held by, the need to have the firearm permit specifically state what license types that firearm permit is associated with. And there was no logistical way by which we could associate a firearm permit with multiple licenses and synchronize the expiration date. And so the decision was made, we needed to just completely separate the expiration dates. I'll be talking a little bit more about things and how they'll be rolling out, but needless to say, this bill gave us the ability to continue moving forward with the assessment program and addressing this technical issue. It also amended the definition of alarm system to help clarify what entities need to hold a national alarm company license. Prior to the bill, the law read as police are expected to respond, and that verbiage was used to define an alarm system that required licensure. The amendment basically said that police may respond. It also clarified the disclosure which must be provided to a consumer at the time that an alarm agent agreement is being entered into, if that agreement has an automatic renewal provision. And specifically, the amendment clarified that that only applied to residential agreements and not anything in a commercial market. That concludes my update regarding enacted legislation from 2017. I'd now like to talk about the Law Enforcement Security Guard Guide. I know we've had several conversations before on trying to get this information out to the actual law enforcement folks. And so we've been routinely sharing the guide. Oh, okay, sorry, I thought you were telling me. Okay. We've been routinely sharing the guide with law enforcement entities when they contact us regarding they maybe have in a situation where they have an individual working in a capacity of a guard or proprietary officer, and sometimes they're seeking clarification on the registration the individual's required to hold, or if an individual that's working armed can be employed by the certain employer. So on a one-on-one basis, we share it. But we're trying to now, and I talked about this before, where we've put this out through the Clutch Users Group and other different forums. Well, we've now officially reached out to the California Police Chiefs Associations and the California State Sheriff's Associations in hopes of trying to have discussions on utilizing their infrastructure to get the guides out. In regards to the Bureau's efforts on the consumer guides, alarm and locksmith, we've talked about it before, the various efforts that we have done, Congress of California Seniors, as well as the Contractor State License Board. And the committee, I believe, 2 meetings before, came up with, one of the committee members here came up with a wonderful idea, is to work with legislators. And because legislators are often out there in the public and holding their town hall meetings. And so we did reach out, the Bureau reached out to the Assembly Rules Committee, and we were afforded the opportunity to go down to these meetings and present the brochures first in August with the Assembly Northern District Directors Network, and on September with the Southern District Directors Networks. And basically, these venues now is expanding the ability to get the word out, because they are sharing them in town halls, and we're currently working on whether we can modify the document to provide a condensed version that legislators would include actually on their personal websites as well. So we're working, continuing to get the word out on that particular guides. So, now I want to talk a little bit about the implementation efforts of the new firearm permit assessment that's required by Business and Professions Code 7583.47 that was put into law by SB 1196 in 2016. So basically, that bill went into effect January 1, 2017, and it required the Bureau to have this assessment program, an assessment to be completed by security guards who are seeking an initial firearm permit. The implementation by law required the Bureau to be done in 2 steps. The first entailed executing a contract with a licensed psychologist to assist the Bureau to identify the appropriate assessment instrument. The second step involves securing a third-party vendor that possesses the facilities, staff, and overall infrastructure to be able to issue the assessment in accordance with the assessment manufacturer's requirements and at various geographical locations throughout the state. In reality, carrying out these 2 steps, i.e. executing 2 state contracts in a 12-month window of time, is a monumental undertaking. And while the Bureau's efforts were moving forward as we were needing to do so for a January 1 implementation date, it became apparent in about July of 2017 that it was going to be very, very difficult to have the second contract with the third-party vendor executed by January 1. For this reason, we reached out to the legislature through the Department's legislative office, and as previously noted, the language was added in Senate Bill 547 to provide an additional 6 months for the Bureau to put this in effect. The language was written, however, in a manner that if everything moves forward more quickly, that we can implement this sooner than July 1. Due to the fact that the Bureau is currently in negotiations for a contract with a third-party vendor, I'm not able to provide you specifics regarding the selected assessment tool. I can tell you an assessment tool has been identified, but without compromising anything in moving forward with the contract, the extent that I can share is that the Bureau continues to have discussions with the appropriate individuals that are involved in executing this contract. We've identified an assessment, and we hope to have something in place very soon. I can also share with you that all the required staff that were identified through a budget change proposal because of the additional workload that this new assessment was bringing to the Bureau have been now hired, and they are in-house in the Bureau, and they have been trained on the brief system overall, contracting, state contracting processes, everything, so that when we are ready to go live, everybody will be ready to go live as well. That concludes my Bureau Chief update. Questions or comments from the committee?
Madam Chair, are you able to say, with respect to the assessment for the firearms permit, whether that assessment will be just a written exam or both a written and personal interview?
So by law, if you look, I can't answer that question because the law is very prescriptive on what the Bureau is permitted to do regarding the assessment. And per 7583.47, it is a written assessment.
Chief, I had a question on AB 1247. I'm sorry, did we just say that shouldn't be on the agenda?
So 1247, because it was not noted on, it was not a chaptered bill. It's a bill that's continuing to move through the process. We focused on chaptered legislation. Any other questions regarding anything on the update?
I have a comment regarding your update. I wanted to thank you for the spearheading the revised form, especially with the suggested range qualification schedule. That's been very helpful in showing people that, posting on websites, and just handing it back to them after they complete the initial training or any one of the range qualifications. Now they have something they can refer back to, because it was always kind of a question, yeah, generally 6 months apart, but not, closer than 4 months apart. So that's very helpful. I know, I assume some additional revised forms are going to come through once the assessment starts. I want to make a couple suggestions for any future revisions of those forms, is to notate something on there regarding one color ink. There is a section on there that the applicants or students fill out, and then of course there's sections on there that the firearms instructor fills out. So easily things can be filled out in 2 different color inks, and I've heard of paperwork getting kicked back because forms are filled out in 2 color ink. So maybe if that's clearly notated on any revisions on the forms itself, that would help.
So I thought we had some references on particularly the certification page, because I know that one of the things that has happened, and it's not, so you're not going to get a deficiency if the applicant part of the document is completed in 1 ink and the instructor's certification is completed in a second. Or if it's a renewal and there's 4 requals being provided and those may have different ink, because the expectation is not that the firearm instructor is completing all 4 recalls at one time, that can be happening over the 2-year term. However, and this is something that's noted as a deficiency, and I thought we had, and I'm hoping staff are looking this up, we had comments to the effect that if the actual 1-page certification page has things in different ink or looks like different handwriting, or something scratched out and another data point provided, that's going to be kicked back, because we have no way of knowing whether it was the instructor that changed this or the applicant after the document was provided to the applicant to submit. So are you able to pull that up? Okay. So having said that, duly noted, I know we have verbiage to something to the effect of correcting the document. I want to confirm on the ink, but those are good points, because again, it all goes back to the issue of the integrity of the document and ensuring that nobody has modified it or done something different in advance or after it's left the instructor's hands. But it is still difficult to kind of find out. I mean, we will validate that the instructor has a valid instructor certificate at the time that the certifications were completed. We will validate the facility has a valid facility certificate at the time that document was completed. So those are some of the program integrity things that we ensure. The ink stuff gets a little bit more difficult, but we do what we can, because it's a good point. We
Right.
don't know who may have altered the document.
And I just did a quick review of the updated application and first qualification form. It may be spelled out in the details, which are on the back pages typically, but on the front page, it clearly states, for example, type or print clearly. So that might be an area, in 1 color ink or something like that.
Okay.
Because that's going to be looked at rather than, all the details on the back. That's going to be looked at when they're actually filling out the form. The second suggestion was a clarification on copies being accepted or not. When it comes to renewal of a firearms permit, some applicants may have misplaced requalification forms 1, 2, and 3. It happens very frequently. A lot of facilities keep scanned copies or hard copies for future reference when their clients or customers come back, hey, I misplaced my first, second, and third requalification form. So I don't know about any clear direction as far as can copies be provided at that time, or does the applicant have to come back and have the instructor fill out a wet ink original form again? I've heard 2 things, so maybe some clarification on that on the new forms when they come out.
Okay, duly noted. Do we have anything on the ink thing yet? Is it just, okay, so. Okay, in the instructions, though. Okay, so we'll take a look at that, thank you. Any other comments, questions?
Good morning, Chief. I had a question regarding the renewal for the guard cards for security officers. Is there any way or any thinking around how any other entities could help facilitate the process to relieve the burden of the Bureau to kind of like help expedite the process a little bit?
So, very good question. In accordance with Bagley-Keene, we haven't noticed anything regarding discussions on that specific type of effort. It could be something that later in the meeting, when you talk about things that you would like to have discussed at future meetings, that we could add. But in accordance with Bagley-Keene, the conversations are restricted to what's agendized, to give anybody, the public, an opportunity to also weigh in if they also have comments in that area. I can say generally, because I know that I referenced here in regards to the firearm permit and the changes that we're making, that this is part of our overall efforts to try to reduce deficiencies, to try to identify opportunities where we become more effective, efficient. That's also part of what I referenced in the breeze, because we all know, particularly for guard applications and all employee applications, coming in breeze can significantly reduce timelines. We've had conversations in past meetings about how to avoid some of the pitfalls with exceptions which occur when the DOJ response doesn't align with the employee app information. And if you'd like, we can have continued discussion on that in a subsequent meeting by requesting that potential discussion.
Yeah, I'm interested in that and willing to help any way possible.
No, absolutely.
To help relieve the burden.
So again, the only issue right now is that we stick to what's on the agenda for today, but we can certainly consider that for discussion in a future agenda. Thank you. Any other comments or questions regarding anything that I just presented in the Bureau Chief update? So Tim, you're not going to say, good job, CAA? To you?
I did appreciate working with you on that, and that.
No, I just was thinking that you guys did a great job. So
Yeah.
I wanted you guys to be truly recognized for that.
Yeah, and I think, we have those meetings, and it's an opportunity. We appreciate you driving it home and giving us the information that we needed to send out in all of our materials. So we still have stuff to work on, I see, but it is good. Started with driving it through my company, which I thought we were farther along than we were, so that was a good
Yeah.
start.
No, I was pleasantly pleased when the stats were provided to see such a significant uptick for the alarm agents. So. Okay, seeing no other comment from the committee, do I have any comments from the public on any of the items that were involved with my Bureau Chief update? Seeing none, let's go ahead and move on into item 6. Discussion regarding the BSIS fee adjustments in SB 547. And so in your packets, there is a handout. For this particular agenda item. And what we're trying to now do is talk a little bit about the actual implementation of the fee increases. We know that we have to have these in effect by July 1. These were put into place by SB 547. As background, the need for the fee increase, I think you all have heard enough times on the background on why we got to where we got to, and let's just kind of move forward to now what. And so the now what is, how is it going to roll out? How is it going to be implemented? So the new fees will go into effect July 1, 2018. And so those new fees are going to be both initial applications as well as renewals. And if you recall, renewal notices are sent out 90 days in advance. So that means all the brief changes have to be in place by March of this year in order for renewal notices to be going out and reflecting the new fee rate for renewals that are happening on July 31st. And so the handout is kind of giving you a little breakdown on when is it going to be the current fee and when is it going to be the new fee. And so in general, any application that is submitted on or after July 1, this is an initial app, is going to require payment of the new fee amount. The day it's transmitted with Breeze with the payment is the day it's deemed submitted. If it's submitted before July 1, it's going to be the current fee amount. If it's submitted on or after July 1, it will be the new fee amount. In regards to renewals, it's going to be the new fee amount even if you pay the renewal fee before July 1, 2018, but your license expires after July 1, 2015. So let's back up here again. We've got bureau licenses expire at the end of the month. So we've got a July 1 or July 31st, 2018 expiration date on XX bureau license. The renewal notice will be received sometime in April for that renewal. The fact that the individual license holder makes payment in May of 2018 for a renewal that expires in July 31st, 2018 does not mean the current fee applies. The new fee applies by virtue of the fact that that license does not renew until after the July 1 point in time. So in regards to Breeze, it's the day submitted on the initial, or the day is driven by the expiration date of the license. For paper apps on initial, it's the day that the envelope or the whatever means of submitting that information postmarked. So if an application is postmarked before July 1, it will be subject to the current fee. If it's postmarked on or after July 1, it's going to be the new fee. Now, we're anticipating in that month of June having a lot of things that could be kind of wobbling back and forth, which means for us, there's going to be additional workload on the cashiering end in licensing. So we're working now on hiring a permanent intermittent employee to come on board for about 6 months to kind of assist us with this extra work that we're anticipating, with this little bit of kind of jostling back and forth with some of the confusion on is it current fee or new fee. And so we'll be continuing to work with the industries that represent our licensed professions to continue to get the word out, because I think as we get closer to that, in particular, there's going to be a little bit of confusion. So the handout is kind of giving a general guideline on employee registrations. We broke it down by Breeze, paper for initial and renewal. Firearm permits, remember, only paper. There's no Breeze transmittal for firearm. Company licenses, and that includes the training facilities, the training instructors, and the qualified managers for those license, or for those practice acts that have a separate license for the qualified manager. Again, very similar guidelines. Expiration date, date post-stamp, date submitted. The one is going to be a little bit different is the baton permits. Because the baton permits, the Bureau does not issue directly to the permit holder. The way the law is structured, the baton permit is purchased by the facility, and the facility administers it. So any baton permit that is purchased before July 1 will have the current fee. Any baton permit purchased on or after July 1 will be sold, or not sold, but provided at the higher fee. We'll be continuing to send interested party emails out as we get closer to the implementation dates, including more refined information on the fees. I can't emphasize enough, this, if you haven't already done so, now is the time to sign up for the Bureau's interested party list so that you're getting these informational emails. A lot is happening between now and July, where we've got the fees that are going into effect, we have the firearm assessment that's going to go into effect, so a lot of things happening, and the best means to hear from the Bureau, because I mean, it would be in a perfect world, we would be able to send letters out to every license type, but with close to 385,000 licensees, that would blow up our budget. So interested party list, interested parties list, interested party list. Get on it if you're not on already. Do I have any questions or comments from the committee regarding anything that was just presented on the fees? Any comments from the public? Seeing none, we are now at item 7. We're moving very quickly, actually. Which is discussion of the technical and statutory and regulatory updates to the Firearms Training Manual. During the July 1, 2016 Advisory Committee meeting, Bureau staff and committee members discussed changes that were needed in the BSIS Firearm Manual. We took your feedback to task, and today is Sam Stadolsky, who is the Bureau's Deputy Chief over Enforcement and Disciplinary Review Units. We'll be presenting and discussing the draft changes that the Bureau is proposing to the Firearms Manual. In your packets, you have a copy of the actual Firearms Manual, as well as a one-page handout that kind of encapsulates the salient points of what we're looking at to change.
Morning, everybody. Look at your top sheet that will, it outlines the updates that were made over the manual. So starting with just overall updates, we wanted. Can you hear me now? Okay, so starting with the overall updates, we wanted to go through and make sure that all of the references that were made to law was actually being made to current law. So we went through and replaced all of the penal code references, the business and professions code, as well as incorporated the new sections of California Code of Regulations to make those current. We also added chaptering language for each section of law reference so that we know when that particular section of law was in there, so we can regularly update it now without having to replace every single section that's referenced. Then from there we went in and worked on some more specific updates to the manual, starting with adding a new section that was promulgated into regulation last year. And that was section 635.1, had to do with the acceptable targets for use during range qualifications. Again, we were adding that to the manual because it wasn't in there previously. And that addition you can find on page 14 of the document that you have. The next item that we wanted to update was the information that covered associating a firearms permit to a qualifying license. With the changes that were made in SB 1196 that requires a firearms permit to be associated to that particular qualifying license, we wanted to add language in there to help clarify that. And that language is on page 19. And then moving on from there, pages 20 to 21, we wanted to add updated information to align with the new regulations regarding the review training course required for renewal. That language was clarified a little more in the reg change that went through and was effective in 2017, so we just added detailed language to make it more specific. On page 23, the manual had two different lists. It lists the acceptable documents that you could use for citizenship, and it had a section that said the documents that were not acceptable. We wanted to focus instead on the documents that were acceptable, and we didn't want to get into the weeds in the manual for instructors. We didn't want to make it confusing by listing out items that may or may not be acceptable moving forward. So we wanted to remove those and focus more on the items that were acceptable. So we proposed to delete out the unacceptable documents so that you just have a checklist to look at the document that's being presented and know whether or not that's acceptable. Pages, this is both page 27 and 75. It's referenced twice in there. Wanted to update the language as it pertained to transporting a firearm. This is a question that we get in a lot at the Bureau, and we did some research and we looked at how the information was presented in the manual. And one of the things we looked at is that the penal code sections that were listed, we had both sections that referred to carrying a firearm or transporting a firearm in a vehicle, as well as carrying a concealed firearm. As the Bureau, we do not have anything to do with concealed weapons. We don't issue concealed weapons permits. We're not going to regulate the carrying of a concealed weapon. So we wanted to remove those references because it was creating even more confusion, and we were getting a lot of questions on that. So And that moves into the next item on the list, pages 34 and 37, is where we went through and actually removed out those sections of the penal code that has to do with possession of a concealed weapon. BSIS is not one that needs to be out educating our licensees on concealed weapons. They need to consult with local law enforcement or have their own legal interpretation of what their rights are carrying concealed. Next change we made was on page 47. We wanted to clarify the role of a security guard and a proprietary private security officer. The way the language was in the manual we felt was a little confusing. It kind of blended them in together, and we wanted to really go in there and highlight the difference between the two, being the Private Security Services Act as well as the Proprietary Act. They're two separate acts. A private security officer is not necessarily a security guard. They're both regulated under their own act and have their own set of rules to follow. The next changes we made were pages 92 and 97. A lot of it was, in this case, it was correcting a typo that was in the manual. It had to do with the exam score. It said it was out of 51 points when it's actually out of 52 points, and this was creating some confusion as well. We wanted to make sure the language is specific so that the instructors know how to grade the exams. They know what the information is or what the score is to be. And finally, moving towards the latter half of the manual or in the very end, page 97, we had, for a number of years, the manual had peace officer FAQs. And as we went through those, there was a lot of information there that wasn't necessarily the best information for the Bureau to be putting out, because peace officers have their set of rules that they need to follow under the penal code, and it's not the Bureau's place to inform or instruct peace officers on the rules that apply to them necessarily. We can let them know the rules that apply to them as it pertains to the Bureau and the Practice Act. So we replaced this peace officer FAQs with our Bureau information on peace officer exemptions. And this was something that we worked on for quite a while with our policy unit, and really laying out how the peace officer exemptions work for the private security industry, most notably, as well as firearms. So we wanted to replace that information with something that is more instructive based on the Bureau's needs and based on what the peace officers are looking at out of this manual. And then finally, pages 105 to 106, we revised the language as it related to security guards, bodyguards, and peace officers. There was a lot of information presented in there, and the way it was presented was somewhat confusing. We understand that, there was confusion that a bodyguard's not a security guard, but arguably the duties that a bodyguard is carrying out are security duties. So we wanted to really outline that a little more so that it's a little more specific and it's not as confusing. It gets very convoluted when you have somebody who's a peace officer who is then working part-time. There's a lot of confusion as far as, how far the peace officer's rights extend. So we wanted just to clarify that language a bit to make it a little less confusing and a little more specific to the Practice Act and the parameters in which the Bureau can regulate. Any questions?
Essentially, in looking at the manual, when policy and Sam and I were looking at this, there were things that were being stated that went over and beyond the scope of the Bureau, the four corners of the Practice Act that the Bureau is entrusted with to regulate. We're not entrusted with regulating the penal code. We're not entrusted with regulating other issues that are outside of other activities that may be associated with the private security industry. So for that reason, the manual was looked at from the perspective solely of what the Bureau has jurisdiction over and providing clarification solely for those issues that relate to the statutory mandates and the regulatory requirements associated with the licensed professions. So most of this was needed cleanup. We know that the penal code has amended in relation to firearms multiple times since this thing was first put into place. So it was sorely in need of updates. And so this is the first and foremost what's reflective in the changes. And then the other driving force behind the decisions that were made on what should come out, what should be added, what should be modified, related to just exactly what I talked about. The questions were asked. Is it in the Bureau's Practice Act? Is the answer in the Bureau's Practice Acts? If it's not, where is it? What code? Do we have anything to do with that code? No, then we should not be responding. And notably, the issues that were provided in regards to law enforcement, it's not our job to tell a law enforcement agency what their employees can do. It is the law enforcement agency's responsibility and the law enforcement officer. So many times it was deferred to, this is what the BMP code, anything over and beyond, you need to seek those questions and responses elsewhere. I know the manual is pretty significant. I do want to hear back. I was, hoping maybe today would be a forum, but I understand it's a lot to digest and maybe not be able to provide all the feedback. I guess one of the things I want to talk about is there are changes that are being here. This is a draft. We're going to be rolling it out, and some of these could be game changers in the manner in which these classes being taught by the firearm instructors. And so first and foremost, before you roll out a training guide, is you train the trainers. So I would like, if potentially, since it kind of loosely relates to the draft changes, have a little brief discussion on thoughts. And within the parameters of Bagley Keene, you think? Okay, so I would like to get ideas from those of you that are particularly involved with training or even in law enforcement, if you have ideas, how we can get this word out. So I'll start with any questions regarding the manual or any comments regarding the proposed changes.
I have a few. If, now that I understand you want to go that direction, I'll be happy to discuss the suggested changes that I had after reviewing the draft. On page 13, it talks about obviously 50 rounds for practice, 50 rounds for scoring. There's some confusion in the industry when applicants are doing multiple calibers. And Simon's shaking his head next to me here. So my understanding is 50 rounds of practice, 50 rounds of scoring per caliber. So the confusion that I've heard in the industry is, okay, once they've done their first caliber, for example, qualify with the 9mm, did 50 rounds practice, 50 rounds scoring, and then after that, if I choose to do a 40 caliber, now I only have to do 50 rounds because I've already done 100. It's my understanding, and I think it should be clarified on page 13 where it talks about the 50 rounds practice, 50 rounds scoring per caliber. So it's not just the first caliber you do that day.
No, if I can just answer, this is the information on page 13. It's strictly out of reg. So this is the outline of section 635, which is the firearms training. So any potential changes to that is actually a regulatory change. It's not just the manual.
So maybe I'll pose a question then. So if an applicant is doing multiple calibers at their initial firearms class, do they have to do 100 rounds per caliber?
That was the way we've interpreted the law, yes.
Okay, then my suggestion would that to be clarified in the manual then.
Okay, and that's exactly what I was going to say. While maybe perhaps it can't be clarified at this point because that would involve changing regulatory language, which would have to go through a prescriptive process. We will work in researching whether that clarification can be done elsewhere in the manual without having to go back through the rulemaking process. It may require having to go back through the rulemaking process, and that's additional research that the Bureau has to carry out. But knowing that confusion exists, knowing that it is an issue that potentially could be addressed, we'll look into it.
And then on page 49, it talks about traditional classroom training for the requalification, 2-hour refresher, use of deadly force, avoidance of deadly force. There's other references, for example, on page 96, it doesn't clarify traditional classroom for range qualification, 2-hour refresher. And in the industry, people are starting to do that online. So you may want to clarify that the 2-hour refresher is supposed to be traditional classroom, as it says on page 49. 49. And then the test, I think the
I'm sorry, can we rewind so I can follow through?
Sure.
So on page 49, as you're saying, the very first reference,
says traditional classroom training must be used basically for the 2-hour refresher. That's done with your requalifications.
So that is the manual reflecting section 632 of the regulation. So that is language that exists in regulation.
And then on page 96, it doesn't say anything about traditional classroom training for the requalification. So maybe just to, sync those up so we have the same information going forward.
so Sam, I just want to make sure. Section 633, we're referencing reg there at this point,
Right, correct.
So that is straight out of the rulemaking, that's straight out of Bureau regs. And so the other page that Simon is alluding to is what page?
96, the requalification topic on the bottom.
And that is an area of the manual where we can add clarifying language because it is, it fills in on the existing training outline that's in reg.
And then on the test, I really like the most recent information that was put out regarding scoring and the number of questions being 52 total, 50 written answers, and then 2 individual diagrams, which count for 1 point each. I think the test itself is still confusing for the applicants because the test itself is numbered 1 through 76. So if the test is worth 52 points, why don't we label the test 1 through 52? So 1 through 50 are questions that you're going to select A, B, C, or D in some cases, and then 51 would be a diagram, which could be A through J. 52 is a diagram, which would be A through P. So we have 52 total questions. It's worth 52 points. As it shows now, it shows us 76 points for the applicants. It's still confusing for them.
So you're saying do a breakdown more on the scoring so that on the actual written exam score page where they're actually putting their answers, it is broken down to be
Correct. Yeah, they see 52 questions because the test is worth 52 points. Right now, they're seeing 76 possible points, which is not true.
And that has to do with the diagram portions that is.
Right, so rather than numbering those with numbers, do A, B, C for those diagrams.
That's actually on the exam workbook.
Which is not here today, but.
Yeah. We can look at that.
And then last, just a comment about removing the references to concealed weapons. I understand you don't regulate that. However, I do think that should be part of the training initial firearms. We get questions all the time, well, what if I take public transportation? Could I put a jacket on over my uniform and my weapon? No. Now you're carrying a concealed weapon. So I do think a reference should be in there that you could be considered, you will be considered carrying a concealed weapon if you're wearing your uniform and put a jacket on and go to and from work in your car, on the bus, on a train, go into a convenience store before or after work. It's different than being in full uniform with their weapon exposed, patches showing, which would be legal. Putting a cover-up jacket, a sweater, or something like that on would be considered carrying a concealed weapon.
Could it be argued that if they're stopping off to go shopping, that they don't, at that point, the law is very clear, they're only allowed to have the exposed firearm on their body or on their person while on duty or going to and from work
Absolutely.
in the range? So what you're saying is
Clarification.
on if you do this, you're now potentially going into, crossing over to here and with a concealed weapon, and you don't have this authority.
Absolutely. I
You
think
don't have this. So how did we tweak the CCW? I mean, we took out the things,
Part of the penal code had referenced transporting the firearm in a locked container. And the way the manual had kind of articulated it was it showed the exemption for a uniformed security guard going to and from work, and then it said, while in transport, it needs to be in a locked container. When we looked at that, we needed to separate out the concealed weapon versus the, possession of a firearm. So, with that said, I mean, I understand what you're saying. The moment you put a jacket on, the firearm is now concealed, you're moving into a different section of the penal code. So, and maybe that's something to discuss and consider, that that information still should be in the manual, only presented differently than how it's pertained to transporting.
Correct. Just as part of the initial training, I think they need to know that. You know?
So, Matt, can you give us an example in the manual where you see language that is currently there that you believe could be modified as opposed to removed because of the concerns you're raising?
I'd have to go back to it. I don't have that reference in front of me, but I'll definitely look into that.
Okay. Anything else?
I assume information on the assessment will be included before the renewal's put out,
Before the renewed one has gone out?
before the renewed manual's going to go out, so we don't have to print this out multiple times.
That, I mean, we will strive. I think some of these, I think the issues that we have is there's outdated penal codes. It's not in a good place. And if this is what we're training on, it's not doing the best job for the guards or anybody that's seeking a firearm permit. And I would hate to postpone it because for the assessment. But I can certainly take into consideration the fact that doing back-to-back changes could create hardships and kind of look at it from that perspective. But again, I want to talk a little bit too on rolling this out. So once we get to a point that this is where and I don't know, it may involve bringing it back, in which case yeah, Matt, you're right. We're basically on track with the assessment as well. The hopes, the Bureau has really committed itself in many ways, through a lot of the fee discussions to see what look at what we're doing and what we need to do better. And this was clearly one of them. And at some point, maybe even consider moving out just the changes of the manual initially so that we have correct penal code sections cited. So, because that's just not good. So we basically take care of this from a low-hanging fruit perspective of what we really need to address. And I would say that takes precedence. We've got to get this up to where we are in today law from the references, and then continue to have dialogue. But that, and then to kind of roll it out with these additional things. Oftentimes I like to use the phrase, don't let perfect get in the way of good. And I think there's a lot of work to be done here, but there's a lot of things that we can do now to get this into a better place and try to move it forward. Thank you. But I do want to chat a little bit.
Chief, may I
I'm sorry,
add something here? Assuming the Bureau is going to want to reintroduce the uploading of documents and debris eventually for the firearm requals and qualifications, shouldn't there be a little bit more detail in the registration or administration section of the manual for the training facilities to tell the students this is the requirements from the Bureau as far as uploading these documents?
Breeze launched on January 2016. For over a year and a half, we did all kinds of things, including very, very, very explicit instructions on the Breeze application form itself. Right at that point where the applicant is being told, you need to scan and upload a copy of the actual application form. That document is required to continue moving forward. And we still continue to have 1 out of 2 not provided. I honestly believe it's going to take a lot to put that document back onto Breeze with the environment. We, like I said, it wasn't just, the decision wasn't made lightly, but we can't, with the number of applications that we receive, we can't have that large of a number of applications come in with those deficiencies and be able to keep up with the processing times that we are committed to doing, not only statutorily because of the renewal timeframes, but also initial licensure. We understand the longer it takes for us to issue that license, we're impacting that individual's ability to go out and start working. And so I think it would really take a lot, because we tested the water, retested, retried for over 18 months and couldn't get it to a good place.
Yeah, I bring that
That
up.
I don't
only-
think, I don't think the firearm permit application is going to be going back into a breeze environment. It was just much easier to keep that one in a paper.
Right, I just bring it up because when I've taken the requal classes, I don't recall an instructor ever saying, oh, by the way, this is breeze, and when you have this form, this is how you're supposed to do it. And I just thought maybe that was the perfect place to try to reintroduce that back in.
I mean, it's certainly discussions to be had because, you know, every other application type, it's part of my first thing on the Bureau Chief update is, what's the breeze participation rate? I agree, if we can get it there, it was a hard decision for all of us to make because breeze is a great system, but the workload, we were drowning. We were drowning in the workload, particularly because the way the firearm permit is structured and you don't have any grace period. It not only created deficiency workload, but cashiering transactions have to be shut down on the date of the expiration. So when we had this unusual things, we were creating additional workload, not only from the perspective of the deficiency, but projected workload for breeze in relation to the new cashiering staff that we added on was over and beyond projected, because now we had to, so every 1 out of 2 firearm apps not only had to be issued a deficiency letter to the applicant and all the steps that are required to process resubmitted information, but 1 out of 2 required a cashiering analyst to have to completely reopen a closed transaction, transfer the funds, move it over, which created a lot of work. And so it would be a very difficult decision to roll that back out there, given what we experienced and the backlogs. And honestly, those backlogs resulted in escalations that went to where you would think they would go to, the legislature, the governor's office, and we tried to continue to keep up with that workload, but it just caught everybody off guard. We kept trying to take the mitigating steps to address it. We couldn't get out from under it. There was just no way, and it continued to be. We put it twice. I mean, right there on the breeze application form. Don't move forward until this. We put stops. We did all kinds of things, and it never got to that point. A perfect world, I wish we could, but I just don't see it. So rolling this out, how much engagement is going to be involved with the instructor? Is this a matter of just rolling the manual out and them having and kind of a document that highlights the changes and highlights the purpose? Or are we looking at having to roll out a formal, workshops to help these folks?
It is an improvement. I mean, it's updated, and it does clarify some of the questions that myself as an instructor was confused about scoring, even the testing procedure. However, there's a couple of things that I think I'm not sure if you guys are allowed to do, as far as maybe adding a little bit of verbiage on qualification, the initial qualification at the shooting range and renewal, that the firearm has to be drawn from a holster. Because there are training facilities that do not do that. Indoor facilities do not allow holsters, so they just have the guys basically on a ready position. And also, since it's under time limit on the course of fire, does the time starts when the instructor gave the command to fire or when the first shot is fired?
Does the reg address the holster issue?
The reg does not address the draw or the holster or the timing.
Correct.
So how did it get to the point, if the regs don't address it and the manual doesn't address it, that the determination was made that the draw has to be from the holster?
It's part of the training.
Yeah, the
I mean,
manual
it is here.
Man,
They have
okay.
the figures and, but the thing is, is it something that is required when they're doing the actual qualification, initial and renewal? And also what type of holster carry, because now I'm seeing now you got the marijuana stores, they have guys that are carrying holsters right on their rig, on their tactical vests. And they have guard cards, they have firearm permits. Now, I think there's a part here that says that, you can only carry the firearm in which you're, in a manner in which you are trained. But we only, most of the time, 100% of the time, when I train security guards, it's from the hip. It's not coming like a drop leg holster, like tactical holsters, and, so is there something that we can probably clarify that this is allowed or not allowed, or unless you're certified by the training facility?
A suggestion, I think the CCW test and requirement defines the holster. Maybe you could use verbiage and techniques from that process.
Well, and I think the issue, though, is within the parameters of the way the rulemaking, the regulations are established in the law, can we do that without what's deemed an underground reg? So we can't put something prescriptive over and beyond what's already gone through the appropriate, legislative review, or in the case of regulations, the appropriate administrative review of anything that the Bureau is putting forth in the form of a reg packet. But I'm wondering also, in looking within the current the current regulation, that's why I got my book open right now. I mean, it talks about proper position, the draw, the shooting fundamentals. If, there's sufficient foundation, if we're looking, it says general information, the holster and the draw, to drive that nexus to providing that clarification in the manual, because this is here. But that's going to require us to do a little bit of research to make sure that we're not going outside. And so as we do that, again, these are all definite things that need to be had, and I would want to hear from the facilities, or even those of you representing the guard industries, if we did this in steps, with the most egregious being updating the codes, getting that into place, and then continue to have dialogue on the additional refinements that are needed. That nodding of the head, kind of that you see the logic in that type of an approach? Okay. So what I'm hearing is, this is probably going to be another agenda item as we continue to consider some of these issues here, and whether they can be incorporated and come back and report to the committee what our research has come up with.
Well, I know in previous meetings, when we discussed this before, we had discussed doing a work group to actually really get into a lot of the details. Have not been able to do that yet. That's why we wanted to start with this simple update, to update the most egregious stuff, get the references to law fixed, and to update some of the stuff that we're seeing that's been confusing in the questions that we're getting in. So I think this is step one. We can at least get this done, and we do want to move forward to addressing a lot of those concerns that you guys are seeing.
And would it be helpful if sent you an email with suggestions?
Yeah, I mean, that always helps.
Well, we need to be we need to be careful on that, because if you guys recall, I think most of you were involved with the training that was done on the Bagley-King Open Meeting Act, that if we've got multiple individuals from the committee in an email transaction, we've now triggered the public noticing requirements. And so I think individually, communication from legal?
Right. So we just want to be mindful of what they call serial meetings, and so my recommendation would be if you all are okay with it, that we might come back and for that meeting, have the dialogue on those things. That way there can be plenty of back and forth for everyone to opine on it collectively together.
So the issue that I would have is sometimes we don't even know what the issues that are going to be brought forth till we're here. So for us to be able to agendize it, we would have to kind of know in advance. Can an individual committee member share on a one-to-one basis thoughts?
Yes.
Okay, so then I hear, then, yes, a direct email to Sam, me, or any other the policy member would be fine if you have ideas that you believe need to be incorporated into the manual. It's just we don't include other committee members on it. Based on that, we'll put a distillation together and bring it back before the committee to have the group discussion on the suggestions at that point. So going back then to this version that you have before you, do you see anything that we have proposed that would be problematic and continuing to move forward at this point in time to get, like we said, this low-hanging fruit, the most significant things we need to get out to the training?
I believe it's pretty much clarified. I mean, the scoring part there, I think it's when most instructors will be confused as far as if it's within the 7 ring, it's all 5 points. What if it's outside a 7 ring, it's within the silhouette, or it's a headshot? It's just not going to be scored. I think that's how I take it right now. Because I
That's
think
how
it
the
was
current
struck,
reg is written.
it was removed from the old regulations that a body kill and head shot will be scored as 5 points. That was struck down and was changed to this, right?
Correct.
Okay.
So am I hearing then, Simon, that it is clear in this new version how the scoring occurs, or do you see the need for?
It is pretty clear, but I think the instructors will be like, well, if someone accidentally or purposely shoots in the head, why can't that be 5 points? It's a kill shot.
And that was issues that were brought up during the rulemaking package. That was not a change in the manual, that was a change to the regulation last year.
I think should be clarified that instructors who's going to conduct the qualification should specifically tell that they should aim for center mass.
And I think that would be fine, because that is the regulation. So we're just kind of building on as a point of clarification on the regulation, headshots are not to be scored.
And just to clarify, the target is a B-27 NRA, right? This is the
specific target specifications were removed and it was put into
dimensions?
Dimensions,
Correct.
correct.
Okay.
So if that particular target does fit within the dimensions, then it would be acceptable.
Copy that.
Do you see the need for additional clarification on that, Simon? Most people that are doing the training will know by virtue of the target in the parameters of the reg that it satisfies or doesn't satisfy, complies, doesn't comply. Okay, so now going back to the one question, if I'm hearing overall that, yes, we need to make additional changes and we're going to continue to have dialogue on that, but this needs to be rolled out. And I'm hearing at this point, everyone sees this as a document that would be viable to roll out at this point. And then my next question would be is, can just rolling it out, interested parties, letters to each, obviously this warrants an individual letter to each training facility and training instructor, directing them to the website, identifying the changes. Is there a belief that that's sufficient explanation on the changes? Do we need to do any type of webcast trainings or anything along that line? Or most instructors will see and understand implicitly what we're doing here?
A bullet point summary of the changes like what was handed out to us, I think would be perfect. Previously, when big changes were made, I believe letters were mailed to instructors and training facilities, so mailing, something like this.
Give a
with
little bit more
bullet-
of the whys and stuff.
Exactly.
Okay.
Rather than just referring them to the website, if something like this was included with the bullet point changes, and then something in there about, additional changes will be made in the future type of thing.
Fair enough.
Yeah, I would agree with that. It can be rolled out in that manner.
Madam Chair, and then one other thought, and as we mentioned earlier, we might be able to clarify in the manual and not add anything new, but just clarify where something currently exists with respect to transporting a weapon while off-duty. We removed on pages 29 or 27 and then 39 the reference to carrying in a locked container or carrying it, prohibited practices of carrying it on duty or off-duty. That might be a location and an opportunity to clarify, re-clarify, if you will, that there are certain legal restrictions. One puts a jacket over the weapon. As I looked at the manual, I thought, you know, a lot of this is technical in nature and goes to the instructor. You can publish this right away, and with the bullet points, most instructors would probably get it, understand what they're supposed to do. One component, though, is so critical. I know the company that I was with prior to assuming my public role, they have so many hundreds of armed security officers. That was a worry point for us. Making it very clear how you carry that weapon to and from your location of assignment. And now that we've gone silent on it with this manual, so that instructors don't misinterpret that, there are still rules in place. We're just not addressing them here. Again, we've stricken it out, but maybe instead clarify that you can't, there are restrictions, legal restrictions.
So, can I propose a subcommittee with? So, for those two clarifying points, I'd like to potentially work with 2 to 3 committee members, which would be below quorum, that they work with us in what we're developing. From a legal perspective, any issues with that? Do I have to?
No, but I'd recommend that would that be something that would be open to the public?
So providing an interested parties blast, but basically say we're looking at clarifying these 2 points.
Yeah,
And then,
or an alternative is to just have 2 members.
2 members?
2 members in your subcommittee.
Oh, okay. So 2 individuals, got it. So do I need a formal motion, or can we just?
I'd recommend a motion.
Okay. So what's being brought before us is that in addition to the proposed changes that are before you today, that we work, I think I'm hearing, I want to confirm, clarification on 2 particular points. One is the clarification on the headshot issue, and the second is transport. Is that correct? So do I have a motion to, well, we'll start with, do I have a motion that 2 members of the committee should be designated to work with the Bureau to develop the proposed language to address these 2 items?
I would make that motion.
Do I have a second? So the motion before the committee is that 2 individuals from the committee be identified to work with the Bureau to flesh out the clarification of the headshot issue and the firearm transport issue by a guard. Call the roll.
Simon Cruz.
Aye.
Simon Cruz, aye. Marcel Egley.
Aye.
Marcel Egley, aye. Anton Farnby.
Aye.
Anton Farnby, aye. Frank Huntington.
Aye.
Frank Huntington, aye. Todd Inglis.
Aye.
Todd Inglis, aye. Matthew Lujan.
I don't like the headshot reference, so can we consider anything outside of the scoring 7 ring?
So the motion shall just say to scoring for outside the 7 ring?
Correct, because anything outside of that 7 ring doesn't count as a point. The head's there, some
Okay,
portions
so
of
then I'm
the-
going to have to rescind the motion.
Sorry.
No, that's okay. So I'm going to rescind the first motion. Do I have a motion to appoint or designate 2 individuals from the committee to clarify on shots outside the 7 ring and the transport of weapons by the permit holder.
I'll make a motion to rescind based on the motion not being called for discussion once it was made.
Okay, so for clarification, I rescinded the motion, so the new motion, I'm making a new motion to say that the new, this is where it gets technical here. Oh. The new motion before the, well, do I have a motion from the committee to take a vote on appointing 2 members to assist the Bureau in clarifying the scoring of shots outside the 7 ring and the transport of weapons? Do I have a motion?
So move.
Do I have a second?
Second.
A second.
Okay, so the motion before the committee now is that 2 members be designated to clarify language on shots outside the 7 ring and the transport of the firearm or the weapon. Call the roll.
Simon Cruz?
Aye.
Simon Cruz, aye. Marcel Egley?
So, once we make the motion, are we not supposed to have the discussion that Matt, I believe, was trying to ask about? Because once the motion's made, then we would have the discussion and then we would call for the vote, correct?
You are correct. Yes, you are correct. So let me, you're correct.
Okay, thank you.
Thank you for, it just got a little confusing with the rescinding and all that there. Okay, so before we call the roll, do we have any further discussion regarding the motion to exactly what I stated, seek assistance from 2 members of the committee to the Bureau on developing the language for scoring outside the 7 ring and transporting weapons? Any comment from the committee? Any comments from the public? Seeing none, call the roll.
Simon Cruz?
Aye.
Simon Cruz, aye. Marcel Egley?
Aye.
Marcel Egley, aye. Anton Farnby? Anton Farnby, aye. Frank Huntington?
Aye.
Frank Huntington, aye. Todd Inglis?
Aye.
Todd Inglis, aye. Matthew Lujan?
Aye.
Matthew Lujan, aye. Lynn Morfeld? Nancy Murish?
Aye.
Nancy Murish, aye. Eli Owen?
Aye.
Eli Owen, aye. Stanton Perez?
Aye.
Stanton Perez, aye. Roy Ron?
Aye.
Roy Ron, aye. Tim Westfall?
Aye.
Tim Westfall, aye. Motion passes with 11 votes.
Thank you. So now the question before the committee is, and I'll ask for a motion in a minute. We have 2 ways of approaching this. We have either, we're going to ask to have the Bureau just identify the 2 individuals, or does the committee want to take formal motions to identify each individual that would be assisting the Bureau?
I think we could let the Bureau make that decision.
Okay, so the motion then before the committee will be that the Bureau will be given the authority to designate the 2 individuals with whom we will be working with on these 2 issues that were identified in the previous motion. Do I have any comments from the committee regarding that motion?
I would like to make just one comment. I recommend that our law enforcement representative be considered as a member, given the specifics of that transporting to and from work as they apply to recent changes in weapons laws.
We're getting volunteer.
My good friend, I should say.
I don't have a problem with that.
Todd, would you be open to working with us? Thank you, Stan. I laugh because there's that whole volunteer.
Sorry, Todd.
Do I have any other comments from the committee? Do I have any comments from the public regarding the motion? So the motion before the committee then is that the Bureau be given the delegated authority to work with 2 individuals that the Bureau chooses to work with on the committee to flesh out the issues of clarification of shots outside the 7 ring and transport of the weapon. Call the roll.
Simon Cruz?
Aye.
Simon Cruz, aye. Marcel Egley.
Aye.
Marcel Egley, aye. Anton Farnby.
Aye.
Anton Farnby, aye. Frank Huntington.
Aye.
Frank Huntington, aye. Todd Inglis.
Aye.
Todd Inglis, aye. Matthew Lujan.
Aye.
Matthew Lujan, aye. Lynn Morfeld. Nancy Murish.
Aye.
Nancy Murish, aye. Eli Owen.
Aye.
Eli Owen, aye. Stanton Perez.
Aye.
Stanton Perez, aye. Roy Ron.
Aye.
Roy Ron, aye. Tim Westphal.
Aye.
Tim Westphal, aye. Motion passes with 11 votes.
So the last thing then brought forth is that, do I have a motion from the committee for the Bureau to then, well, no, we don't. We need to finalize that one issue before we start rolling this manual out. Well, let me rewind. I want thoughts on whether these two items should be finalized before this is rolled out, or proceed with the rollout and then refine. Any thoughts? So, the training manual is updated in accordance with the handout and all those changes. And basically, we're hearing these changes are fine, but there's a couple more things that you need to do a better job on, BSIS. And so those couple more things we determined based on the prior motions that we'll work with two individuals to do. So the question is, because my main concern is there's been so many changes in the penal code, and the current manual is so outdated in relationship to that. Do we just roll this out as soon as the Bureau can do in its current fashion, and then continue to work on refining the language on these 2 points and then update it at that point in time? Or do we hold off until these two items are updated? In which case it would be that the Bureau would roll this out again, because we're trying to roll this out, or do we wait until everybody has an opportunity to view that additional language? And I know I'm kind of going kind of like this, but I guess what the gist of what I'm getting to is, are we good with rolling this out right now and then working on the other stuff?
Yes, Chief, I believe it's a good update, and we could always work on the fine prints on these two issues right here.
I would recommend, Madam Chair, that we proceed forward with it, and I so motion that we adopt this manual with the understanding that there will be we'll all have ongoing discussions about future amendments.
Yeah. Yeah, Chief, I think as long as there's the space and the time to continue to make the modification or the changes, I think we take what we have and just roll with it and modify as we need to.
So is that a second?
Yes, that's a second.
Eli, did you have a comment?
I concur, Madam Chair, with rolling this out. I think it looks great. I applaud the team for putting all the hard work into this, and I know it takes a lot of effort.
So the motion before the committee then is that we adopt this, roll this out now, continue working on the other issues. Any additional comments regarding that motion from the committee? Any comments from the public regarding that course of action of the motion? Seeing none, call the roll.
Simon Cruz.
Aye.
Simon Cruz, aye. Marcel Egley.
Aye.
Marcel Egley, aye. Anton Farnby. Anton Farnby, aye. Frank Huntington.
Aye.
Frank Huntington, aye. Todd Inglis.
Aye.
Todd Inglis, aye. Matthew Lujan.
Aye.
Matthew Lujan, aye. Lynn Morfeld. Nancy Murish.
Aye.
Nancy Murish, aye. Eli Owen.
Aye.
Eli Owen, aye. Stanton Perez. Stanton Perez, aye. Roy Ron.
Aye.
Roy Ron, aye. Tim Westphal.
Aye.
Tim Westphal, aye. Motion passes with 11 votes.
So the hour now is 11:50. I propose that we take a lunch recess at this time and then come back to pick up the other items, the remaining on the agenda. Does anybody have any concerns with proceeding in that fashion? No, so then we're going to go to recess. Let's plan on coming back here at 1 o'clock? 1 o'clock. Okay, thank you. The Bureau of Security Investigative Services, July 11th, Advisory Committee meeting. We're back from lunch recess. And so we are currently ready to take up item 8. Discussion regarding retention requirements for investigative reports completed by private investigators and provided to clients. So the Private Investigator Act requires a PI licensee to exercise diligence in ascertaining the facts and information in its for their investigative, and that their investigative reports are true and correct, and requires the PI licensee to provide a copy of that investigative report. Furthermore, it is a violation of the Private Investigator Act for PI licensee to willfully fail or refuse to render to a client services or a report as agreed upon between the parties, being the individual who's hired the investigator and the licensee. However, there is no requirement in the Act that the PI licensee retain a copy of the investigative plan that has been agreed upon between the licensee and the client, or a copy of the investigation report. Many complaints the Bureau receives relate to a PI licensee involves the complainant alleging that the PI, the private investigator, did not render the services agreed upon. In addressing the issue with the PI licensee, when the Bureau addresses this to try to begin to look into the matter, we're often told by the licensee that they don't have the records that were related to the investigation plan or the investigative report. With me today is Sam Stadolsky to talk a little bit more about, he's the Deputy Chief over Enforcement and Discipline, talk a little bit more about what they're seeing in the type of complaints that are filed with the Bureau. And the purpose of this item is to get feedback from the committee, notably the industry member who represents the industry, on whether there needs to be anything looked at in regards to the retention of these type of documents.
Hello again, I'm back. So as Laura shared with you, the Private Investigator Act does not have specified records retention schedule. So we receive, that's mostly, a lot of the complaints that we receive on a PI is, it is alleged PI failed to render services. In some cases, a consumer is angry because they didn't like the result of the services, or okay, does that work? Where was I?
Well,
in most cases, we have situations where they're unhappy with services. They have no real evidence to provide the Bureau to show what they were supposed to get in return. A lot of what we look at is we're going to take it back to the contract. So like for the alarm industry, it's easy to look at an alarm contract and find out what is required and what is promised there. If we don't necessarily have that with the PI contract, or we do not have the original agreement, it's really difficult for us to make a determination whether or not services are rendered in accordance with that contract. And because of that, we'll contact a PI and, services are rendered 2 years prior. They don't have that report anymore, or they have, purged to old records. Without having an actual records retention schedule, it's really challenging for us to really investigate the complaints and to make a determination from there. That's one of the things we would like this committee to consider, definitely with the industry to consider what that would look like as far as a specified retention schedule. Make our job a lot easier, and also it would ensure more consumer protection, and that there's actually a requirement in place.
So I think one of the things that I'd like to piggyback off of Sam's presentation, and thank you, Sam, is are there any best practices that exist out there on investigation plans, the discussions that are had with the client before services begin to be rendered? Is there any best practices that exist out there in the industry in regards to retention of any of these documents, whether that be memorializing the initial discussions or even the outcome of the investigation and the documentation?
my discussion with other investigators, there's really no best practices. Everybody seems to have their own policies. Generally, in the criminal field, when you're dealing with what a possibly death penalty case, the notion tends to be you keep them forever. Other matters, I know some investigators go with a standard 7 years, but there is no best practices. I can say from personal experience, I've got files back to 1999 only because everything I do is digital. And it's very easy to save all my files that way. I don't keep any paper. It's all computerized.
What are your thoughts about moving forward in a direction of putting something into basically a regulatory framework of similar to what we have in other industries here that we regulate? There's an expectation of certain documents, certain records that are retained for a period of time. If something along that line would be something to look at.
I think the industry would have no objection to that whatsoever. Can I ask, Sam, what are the retention policies with some of the other professions here?
I know most commonly, if you look at private security, for example, they have to keep employee records, they have to keep training records going back 2 years.
And if I can ask another question of you, the complaints from consumers you're getting, generally, how old are they?
Those are going to vary. We've had some recently where the complainant was complaining about services that were not rendered 5 years ago. We've had it situations where it's even more recent. So it's going to vary depending on the situation.
And of course, it'd be a realistic. I mean, you're not going to have anything that we would say you never destroy. As you said, there's other things that are governing the record retention on if you've done an investigation on death penalty. We're not looking at anything along that line, but the question is, one, should there be something considered in establishing a retention policy or requirement? And two, if there were in that, what would be a reasonable time frame for these investigation reports?
In answer to your question number one, yes, there absolutely should be. There should be a standard for investigators as it relates to consumer protection. Initially, I've had this conversation with other investigators, and we threw out the number 7 years only because that tended to be the normal retention policy for several other items. I think that's negotiable, especially hearing what Sam says, is they don't tend to go back that far. But overall, yes, I think it would be wise to create a policy of retention. Obviously, where digital is accepted, in other words, I would not require anybody to keep paper files. And it would obviously have to be phased in. You couldn't retroactively ask somebody to keep records for 5 or 7 or 2 years if they've already destroyed them.
So, I mean, I just try to think of even like from my perspective in different departments that I've worked and I've done research and you do the analysis, whether that's an interpretation of a law or coming up with a policy determination. Kind of want to keep it because chances are there might be something similar down the road, that a similar issue, a similar question from which you could piggyback off of that to develop into the next analysis. And I would think that maybe investigative reports would have similar things along that lines. And I think I'm hearing from you, yes, we need to have something in place. I'm just curious why somebody would not have an investigation report, let's say a year or two after they rendered the services.
I can't answer for other investigators. I can answer for myself. I keep everything for that specific reason, including the retainer agreements and the entire file, but I do it all digitally. As far as other investigators, as far as the 8,000 or 9,000 other licensees, I cannot answer as to what their policies would be.
But would there be, you said criminal, we talked about criminal a minute ago, which obviously there's statute that tells us how long we have to keep them by law, up to a certain year, and criminal reports are discoverable and it's public information. Would there be any issue with confidentiality if you're doing some type of, because I would think most of the investigations are civil related, or it could be family court or whatever. Is there any privacy for these people that may be having something looked into in a contract and then, like you said, not happy with the results, and then having a third party come in and go through something that's not criminal, or is there any protection of the people that are involved?
I don't think there's any issue of confidentiality, because I don't see a scenario where a third party would come in and want to look at a file, and I would reject that anyway. I would not allow that.
So
Well, you're asking this board to be the.
yeah,
you to
that's
be
gonna say
the
the third. So I think what I'm hearing is that by virtue of the fact that we get a complainant saying this PI gave me a really shoddy report, didn't answer or did not carry out those activities that we agreed to. And so part of what the Bureau would need and kind of make a determination if we were to move forward with all this is that, well, I'm sorry, is were the services rendered in accordance to what was agreed to? And does the investigation report provide information from which a reasonable person would discern this? Because oftentimes, and correct me if I'm wrong, same thing with what you see, is the investigation can only go so far, because at some point, it's even like when the Bureau is carrying out investigation, at some point, the evidence is not going to be found. And so a complainant could be unhappy that the results didn't go in their direction, as opposed to was due diligence in fact carried out or not carried out in conducting the investigation. But if I'm hearing the question correctly from Todd, is how would people that are part of that investigative report feel for the Bureau to now have a copy of that investigation report? And I believe, and this is something from a legal perspective, I'm not 100% sure in looking out, that investigation report, once it's given to the client, is the client's report, the client's property. Is that correct?
It is, but I'm afraid we're talking about two different things here. The way I interpreted it from Sam was, if a client's not happy with me and comes to me 6 months later and says, you didn't do your job, I want reports, and my response is, oh, I've already destroyed them. That's something that we need to correct. That's one issue. The other issue is, and I didn't, if the Bureau then becomes involved and says, okay, you're required to keep them for 5 years, why haven't you? Or you need to turn it over to the client. And again, if the Bureau wanted to review the reports, I'm assuming it would be with the client's permission.
Correct, and that's where I was kind of heading, that if the client is the one who's the complainant and filing the complaint, then part of the discussion would be, if you want us to look at this, we need to have, your release.
Absolutely.
For the Bureau to consider it. But I wasn't clear if, and that's why I asked, is once the report is given to the client, is it the client's property? And what if that report, it's a family matter and is talking about other individuals other than the client? What are the liability issues? And I mean, Todd raises some good concerns. And
That's what I took. I took it as somebody's unhappy with your services, and they don't go to you because they're unhappy that you didn't provide the information where they wanted, and they're coming here who licensed you saying, this guy's not giving me what I'm paid for, and then wanting them to basically audit or look into, are you providing the service that you say you are? That's how I took it.
And I think the reality is we see both situations.
As far as the confidentiality, I don't think the report, in my opinion, does become the property of the client. Now, vast majority of my clients are attorneys, and the report is addressed to the attorney, becomes part of their case file. Otherwise, though, if I'm working for somebody private, I'm not going to write anything in a report that's going to go to them that has a lot of confidential information about other people. But technically, I believe that if they've paid for it and they've paid for my services, that report does become theirs, and they're entitled to it.
so if they come to the Bureau and now say, I didn't get the services that I paid for. And again, this is really new territory for us. I'm not landing one way or another, going legislatively, doing this, nothing along the line. We have an area in complaints that are filed, and this is one of the things that we can't oftentimes get past a certain point because there are no documentation. There is no documentation.
And I think if the Bureau, or if we did develop a retention policy of a certain number of years, that would alleviate the number one issue right there. It's not going to alleviate the issue of complaints that the investigator did not do their job, but it's going to remove the issue that the reports and the retainer agreement are no longer there.
Because generally what happens is we get that complaint, we have no copy of the contract, we have no copy of the report, because there's no requirement for them to keep it, and we literally have nothing to go on except for a consumer saying, I got shafted by my PI, and a PI saying, I gave them a complete report. I mean, It's not the best result of an investigation.
No, and like I say, I think if we develop a retention policy, that eliminates that issue completely.
But if we develop the retention policy, then what would be, so in the other practice acts, when there is a retention policy, there's also statutory authority for the Bureau upon request to be provided a copy of the record or the report. So again, discussion, if we're moving in this direction, kind of addressing this, should the Bureau then have access to the records? Because how else do we validate that the retention has been in fact carried out?
Perhaps you could parse the policy to state that the Bureau has the authority to get a copy of the retainer agreement, and then the other reports on a case-by-case basis.
So a copy of the retainer agreement, and then if the client has a copy of the report, they by choice give it to the Bureau as part of, and there would be nothing, any issues, because that's what I kept saying. Once the investigative report is provided to the client, is it the property of the client?
I believe so, yes.
Is there anything, I know there's nothing to that effect in the Private Investigator Act here in California. Is there anything, again, any code of ethics, any standards that exist nationally to kind of govern any of these activities?
There may very well be, Chief, but off the top of my head, I'm not aware of them. Like I say, I know my own personal practices is I keep everything always.
I think I'm hearing that at minimum, that retainer agreement could be pivotal. Because that agreement, and should there be very similarly to the alarm agreement, where there's factors or aspects that need to be included in that agreement, like a description of the services that are going to be agreed to be rendered, an agreement for, I don't know, and that's what I'm saying. I'm not saying one way or the other,
No.
but
what concerns me now, we're almost taking a third road here, because we're talking about a number of years of retention, and then we're talking about what can be turned over. As far as I know, there's no requirement that a PI have a signed retainer agreement with the client. It's absolutely best practices. I always do, but I know a retainer agreement could technically be 2 sentences and an email. So now, like I said, I think we're going down a third road as the Bureau want to require that. That might be a bit of a slippery slope.
and I'm certainly not advocating putting more burdens, regulatory burdens on any industry. I guess the discussion here is today is, well, what's the best practice? 2, if we're looking at the mission of the Bureau, which aligns with the mission of the department, it's consumer protection. And so from a consumer protection perspective, the way the Practice Act is currently written, we're not always able to carry out fully the due diligence that might be expected from the Bureau when that complaint is filed, because the documentation is just, there's nothing to validate anything that transpired.
Right.
And so when I mean anything that transpired, the agreed to services. And the point of this today was, should there be something a little bit more to get us to that point? And you're right, we may be mixing apples and oranges with retention, but then for me, is it implied by virtue of retention? If we just go and say, hey, do you keep your investigation reports for 7 years? Yes, I do. And we don't have access to verify that or not verify that, then it's almost, if you're retaining that, then should there be an expectation that the Bureau be provided access? And then the next question is, should that occur? And I'm not saying yes or no. So that's part of what we were hoping to kind of glean from today's discussions, to get a little bit more insight to the practices overall.
Right. Well, and like I say, I think the very first thing we could probably do today, and would alleviate probably 90% of Sam's issues, would be picking. Let's just do a retention policy with a set number of years. You keep your quote investigative file for this many years. And I think that's a good first step that would, like I say, hopefully alleviate a lot of the complaints, or at least that way, if there's a complaint against an investigator, they can't simply say, well, I destroyed that last week. So at least it gives you another tool to say where you're supposed to have them.
So Sam, I do have a question. If the report, on these issues, have the report been provided to the client and that's why we're asking, or what?
We've had situations where it can be either. So we've had complaints where the consumer says, I was never provided my report. I paid this PI 5 years ago, and got to the PI. PI says, I purged that record. I provided them a report. end of story. We've also had situations where the consumer complains that the report that they provided did not provide them any of the information that they hired the PI to seek, which made us in turn ask the PI, what was the agreed upon, services, what services were supposed to be rendered, and that's where it really, we need the two in order to look and see, the Practice Act says that a PI shall not fail to render services, but then how do we establish whether or not that PI has failed to render services? We need to be able to look at their agreement and look at the report that was provided, or in some cases may not have been provided. But since there's no requirement for the PI to maintain those items, there's no way for us to really get in there and investigate and see what all occurred.
It's when I was developing my notes for the presentation, I note that the PI Act does require the PI to provide that report.
If that's part of what the original agreement is, if they provide a report, then yeah.
So if there's an expectation of the retention for a certain period of time, should there be an expectation for consequences for failing to do so?
I would think so.
So normally that would be addressed in probably education, citations, and then ongoing issues and problems where you have just kind of looking repeated patterns, then you take action on the license. And there's nothing in the Practice Act right now that talks about any fines outside of a change of address. So if we were going to go there, I mean, it does allow us to take civil penalties and it does allow us to take action on the license, but that's not a course of action we want to take when it's these type of violations that really are just more, it's not a fitness for licensure issue, but more of you need to kind of do things more appropriately. One of those being giving the client the report. So, what would be the thoughts about if there was movement in the retention policy, also having a form of citation that was education for the first, second instance, something along that line?
I think the industry would support that. I mean, I don't know how else you would require it if there was no penalty for not following through on it. And just to reiterate, in the year 2018 here, everything's digital. The olden days of, I've cleaned out my storage shed where I used to have to, the cases and case files, those days are gone. So this should not be that big of an issue for a professional investigator.
And I think from the Bureau's perspective, it would be more of what was agreed. I mean, almost to the point that should there be something requiring that the agreement be done before services are rendered? Because I think that is going to be, and correct me if I'm wrong, it might be more relevant. I mean, the investigation report, I don't think we're going to be in the business of ever telling a PI you did or didn't do the investigation in the proper manner. I think the more, when we look at it from a consumer perspective, were the services that were agreed to rendered.
And what concerns me, I would hate for the Bureau to start going down the road regarding the actual retainer agreement, because my personal one is 2 pages, but it could be 2 sentences. And if the Bureau is gonna start deciding what should be in that agreement, I think we're heading down a slippery slope. So like I said, my suggestion would just be, let's start with determine a number of years for retention agreement or retention policy and see where that leads us.
Appreciate your insight and comments.
Of course.
Thank you. Do I have any other comments from the committee regarding this item? Any comments from the public?
Chief and members, Jerry Desmond on behalf of Cali, the Trade Association. I want to reiterate everything that Frank Huntington said in regards to the issue. We just recently learned about the problem, and so Cali is looking at, the issue. We're looking right now about the record retention itself, because that's what was brought to our attention. and whether there is a period and what the record would be. What is that record? Because there's a lot of data that goes into an investigative report before it's given to the client many times. So what is the record? What was agreed upon? And we'll also take back the issue of that we're hearing for the first time today, which is should there be a retainer or agreement documented, and should there be consequences for failure to provide, and what would be the circumstances to provide? Is it with the agreement of the consumer, or is it in any case on an investigation? So we'll look into those further, but we're taking very seriously what we're hearing for the first time from the Bureau, that there are issues of the between the consumer and the investigator, where they're saying they haven't got the services that they contracted for or agreed to. And whether it needs legislation, because in our initial analysis, it would need legislation for any one of those three.
You are correct, and I can say that we're not pursuing anything legislatively at this time. We were using the forum here as the committee to try to start just becoming a little bit more educated and better understanding the issues. But there's nothing moving forward at this point. We're just trying to see.
And we'll continue to engage, because if there's a consumer issue like we're hearing, we want to address it together with the Bureau and the Advisory Committee and Mr. Huntington too.
No, absolutely. Totally agree. Appreciate it. Thank you. Frank, it looked like you wanted to say something. No? Okay, sorry. Okay, so...
I just wanted to say thank you, Mr. Desmond.
So, thank you, Sam. As I previously noted at the beginning of the meeting, item 9 was removed from today's agenda, so that takes us now to item 10. And item 10 is discussion on the frequency meeting schedule for the advisory committee. So the current meeting schedule is for 4 times a year, specifically the second Thursday in January, April, July, and October. However, historically, many of the meetings have been canceled due to extenuating circumstances occurring in the Bureau. This raises the issue if 4 times a year is really an appropriate frequency. And I know that the members here as a volunteer committee, many of you, you are participating, and we very much are very grateful to your doing so. But if you're traveling, those costs are absorbed at your own expense. It's not, because it's not a statutorily established committee where the Bureau is not reimbursing. But I'm just trying to get a sense with this agenda item if the frequency of 4 times a year is appropriate, or whether we should consider another meeting agenda schedule. Thoughts?
Yeah, I agree with the complexity of four meetings, especially trying to schedule through the summer. So 2 or 3, I think, would be sufficient.
Any other thoughts?
I can learn how. From our perspective, 4 is doable. I have no problem with 3 if the rest of the group feels that way, but we could certainly continue to do 4.
I agree. From our perspective, I think 4 is adequate. I mean, I was just talking to Roy. The last time we met was the last time we got sworn in, and I think that the work that the BSIS does is important. I think that we can the folks on the committee here can serve as advocates and can provide some pretty good insights. But I think that less than 3. I think that would be cutting it pretty close. So I think if we were to look at adjusting, I think 3 would probably be more applicable.
Any other comments, thoughts?
I'm prepared to support 4 or whatever the committee believes is necessary, gladly.
So, from the Bureau's perspective, we have a lot of things parallel going on, limited resources, and sometimes the meetings have been canceled because we haven't been able to get to the things for the meeting because we're dealing with the other deadlines that are coming up, which results in the meeting being canceled, which is fine if the committee wants to continue at a 4, then there might be those type of occurrences that happen. We know we've got a lot happening this year with the Bureau, with the fee and the firearm assessment. And so if we continued on 4, there'd be good chances that some of those, 1, would be canceled. One or two may be canceled. And in making the cancellations, I don't know how that impacts schedules because people are planning and then all of a sudden we're realizing we're not ready. Because it takes a lot. I know that it seems like we're just coming up with items and just we're here, but there's a lot of back work to get here. And I'm not saying we shouldn't have to do that because that is all part. You guys are giving a huge commitment to the Bureau. But in having the cancellations, the questions I would ask is, would it be better to have a schedule of 3 where the likelihood of that one being canceled and you guys adjusting your schedules accordingly, would it be just more appropriate to go to a 3 count?
My recommendation, or my suggestion would be, I think 3, granted this is my very first one sitting here, but considering the last one was canceled and one before that I believe was in July,
Right.
and today's agenda was not that big, it seems to me that we could probably get by with 3 a year and adjust the schedule accordingly.
My recommendation would be just with the scheduling that you have coming up, where you said you're having to add an extra cashier and just the deadlines of the fees. I think that would be a huge undertaking to try to schedule it during that time. So I think was it Matt or Tim? Did you make the suggestion of maybe skipping like that the summer?
It seemed like that it's July 7th usually or something like that. It's a tough time anyway, and that's right when the fees would kick in.
And prior to, because everybody's going to be trying to pay before, and they're, like Laura said, they're going to be, just drowning. So I think I would concur with, what Anton and Tim and what Laura have said with 3, and then maybe skipping this time frame where you're gonna, with the application deadline, just because that's going to be so busy for you and your staff. So if there were 3, I think that would be sufficient, and then just suspend this meeting altogether.
So, thank you for the comment. I just want to note for the record that Lynn Moorfield has just arrived. The time is about 1:34, and we were aware that you had conflicting schedule today with other commitments, and we appreciate your right. Yeah, just let you know we volunteered you for 4 subcommittees. So yeah. So just to quickly bring you up to speed, the issue, we're on item 10 right now, which deals with the frequency of the meeting schedule. Currently have 4 meetings a year. Those of you who have been on with the committee since its inception realize that it's often difficult that we've had cancellations. And so the issue is, would it be beneficial to just establish a schedule at a less frequency so that everybody can plan accordingly? Do we keep the 4 and then continue on with if things are doable or not doable that the Bureau cancels? Notably, there's major undertakings, as Marcel just shared, that the Bureau is going to be dealing with this year. Do we move forward with an expectation of certain meetings being canceled at this point in time? Do we establish a different schedule? There's also overall the difficulties that arise with the summer hearing, just because we're all very busy. So we're just trying to get a sense of, do we continue the way we're going, or do we look at a change?
Again, I would rather see a set 3 meetings a year rather than a set 4 where they're being canceled.
In setting and readjusting the 4 to 3, is there a likelihood that even if we went to a 3 set meeting that those will be canceled?
Well, we've never gone that we've canceled everything in a year. I mean, I think the worst was during the Breeze transition launch, where we were going on all, cylinders in making sure we had a successful transition. Before and after, right before transition, we canceled the meeting. Right after transition, we canceled the meeting. And I believe in that cycle, it was 2 years, two meetings in that, if you were to look at that window of time. We've never gone below 2.
Mm-hmm. Yeah, I was just asking because if it's the question around frequency, if we're going to deal with the same issue, if we go to 3, then what difference does it make? We may want to consider, take other considerations. I think just kind of getting to Fred's point, Frank Frank's point is that, if I do believe that if we schedule 3 or 4, regardless of how many the number is that the intention is to have the meetings, right? But I do understand, Chief, the huge undertaking that we have coming up, particularly this year with all of the work around the firearm stuff and all of the rest. So I guess, I think, speaking for myself, I'm fine with whatever it is that the committee decides. I guess, as long as we get to a point where we're as consistent as possible in meeting, I think that's my main concern.
And be assured the Bureau strives for that. It's just
I understand.
sometimes it's
Understood.
beyond our control when we just, we've got something and staff need to be dedicated toward the thing that has that outwards, statutory requirements need to be implemented by a certain time and that outward facing. And so, and then also, in full disclosure, policy unit, which is the one that takes a lot of the leads on this, we lost some good individuals to the Cannabis Bureau because a lot of them live out in that area, and so we this year was a little bit tough on us in policy with the legislation moving forward and all this, the assessments, the implementation of new bills, and then to have on not operating on all 4 cylinders in the policy unit. So, but the reason as we when we canceled the last one in October, we started actually having the internal conversation as to whether is it really fair to the committee if we're having 4 set, you guys adjust your schedules for 4, and then because we just can't do it, we have to cancel. And that's why we thought, well, let's just put it forth to the committee what the preference would be. And I'm hearing a little bit of both sides of the arguments, which kind of where we were at. Keep the 4 and do our best at all times to try to have the 4, recognizing some can be canceled. Or there's a benefit of just knowing it's going to be 3 and those schedules are set, and it is.
I think you have a lot of new members, it seems to me. And the prudent thing might be to let it ride at 4 for this year and take a look at how attendance goes. It's the first time that in my memory that we've talked about it, so the decision today would be difficult.
I'm sorry. No, please, I'm sorry.
I was only going to add that I support also whatever decision BSIS would come up with, reminding myself that we serve at your pleasure and to advise on matters that you bring forward and that affect the industry. I don't know that there's anything wrong with scheduling 3, and if there's a need for a 4th meeting, that you call for a 4th meeting. It does impact, I would presume, other schedules as it does mine in planning out. If I know there's a great certainty that we're going to have these 3, as opposed to now knowing there's a great certainty that at least 1, if not 2, are going to be canceled.
Thank you. I saw Mike go up over here.
Based on what's coming up in the summer with the BSIS, I think it'd be better to move forward with 3 a year. And if we did that, we'd be looking at February, June, and October. So June would be well before your July deadlines, and then our October meeting was already scheduled.
So we would have a meeting in February next month?
We would skip the February meeting.
Okay, so you're saying the proposal would be February, June, October, but this year we don't have the meeting till June and then October for this year.
Correct.
That's something that works with all of the deadlines that's coming up in July.
I don't think June works. That's what I was
Yeah.
suggesting.
I
Is
mean,
maybe do April and then suspend June and meet in October. But again, that was just a suggestion.
April might be a lot of prep work, I'm sure. Probably.
You have May, June. So
And well, it seems to me though that in June, the end of the fiscal year, the Bureau would be very busy.
So we run July 1 to June 30th. But if things are proceeding with the assessment, as I'm hoping, April could be very busy. And then July again could be very busy because that's when the fees go into effect. So statutorily, the assessment, the way it was we talked about it earlier item is we were given an extension July 1 through January 1 through July 1 of 2018, but if a date to be determined if we can put everything sooner. In my mind's eye, the expectation isn't that we execute on July 1 for that, that we have to have the contract in place. We have to allow the vendor the time to build what's appropriate with the contract. The Bureau will be working very closely with that vendor to make sure, testing potentially, to make sure that everything's going out appropriately. Things are proceeding. I'm hoping that's going to be done April, May, and then we're going to be gearing up for the breach changes and renewals that are going to have to start happening in April for the renewals that need to start going out in July. So we're busy. In all truthfulness, we're going to be probably busy from April through August, because gearing up on the one aspect and then dealing with what's going to happen. I envision July being crazy with people not knowing as much good faith effort we're getting out there on the correct fees, but having to do all kinds of policy unit, having to respond to the multitude of emails that we're going to be getting. I'm renewing on this date. What do I need to pay? When do I need to pay? And rolling out the changes that now, once we know the assessment's in place, getting the Bureau's website built to either link it to the vendor or talk about what's going to be going on. From the policy perspective, which is the unit that drives a lot of this, it's going to be really hard for us from bandwidth from April through August, in all truthfulness.
Mayor Chief, does it make sense at this point in time to potentially maybe think about, having a meeting maybe in March, skipping the April and June, and revisiting this question in October?
Again, I'm open to the pleasure of the committee and their thoughts, which is one of the reasons we brought this forth. Rick wanted to bring forth to you the things that we're going to have to be dealing with this year, which is extraordinary. I mean, I thought the breeze transition was extraordinary, and we were successful, and that took a lot of effort to get through the chute. And I thank all the Bureau staff and all that Bureau management for that. But I'm seeing equal challenges in this year. So yes, if you wanted to know the truthful answer to that, if we could free us up from April through August, it would be extremely helpful.
Just a suggestion. Yeah.
So keeping in mind, too, that if we have a meeting in March, just to give you guys insight on how we have to go. Because of Bagley King, we have to back in 10 days of notice because there's review processes. We're talking 20 days trying to get the agenda finalized, which basically now we're second week of January. The Bureau is going to be tasked with building the agenda probably within the next 3 weeks, which is doable, but the committee may have to acknowledge or recognize that it may not be as robust of a conversation as some of the items. We certainly have tabled some things that we could bring forth, such as the discussions and finalizing the firearm manual. Clearly, we took an agenda item off today. Those are things to me that will be given. If the committee understands that maybe the discussions may not be as robust as historical ones have been, totally open to trying to do something in March and then not doing anything until the latter part of the year.
I'm fine with skipping the meeting. I think that, what you accomplished today in the committee that's going to be established, but it's not my industry. So I think that with the committee working on the firearms, unless they feel a need, I think it's really, they're the ones that would need a meeting. But if they're working on the committee separately, then I don't see the need for a meeting in March, if that's a huge undertaking myself. Because you have the committee that's going to work, your 2-member committee, I think that possibly you're volunteering
Possibly
for.
if we schedule something toward the end of March, or maybe that last week of March, the back end of March, we bring back the manual, potentially have this discussion, and maybe just it may be that we just have a morning meeting. It may not require us to stay through lunch, but at least we still continue to have dialogue. You still get a sense of things. And then we have that solid window of time to focus and dedicate on what we need to do.
I think that's a great suggestion, and the morning one, that's
be effective.
So, we don't have to come up with a specific. Okay, so what I've been told is that since we're not modifying the schedule formally from the 4, we don't need to take a motion. That what we're agreeing to is recognizing what this year entails, that we're going to cancel the normally scheduled meetings through until, but we'll have the October one, as we've agreed to, the second Thursday of October. However, the Bureau will then do all its requirements of working with the committee members to identify what day in that last week of March will work so that we have a quorum. That's the goal. We have to have a quorum in order to meet. And that we just take our due diligence and appropriately bag the key, noticing that, and we should be fine.
I just want to make a note. I don't know that it affects anybody's job schedules, but the last week of March we'll have some holiday. So we might, I don't know if that's a consideration for anyone. Like I don't have it on my calendar. I think the legislature is out and things like that. So we might want to maybe allow you the last 2 weeks of March. I don't know that that's an issue, but I just wanted to make note of it.
So what we'll do then is, thank you for that. We'll be sensitive to that as we start looking at a possible date, but the committee is aware that somewhere toward the latter part of March, we'll be trying to coordinate something. So does that work? So we're agreeing to, as of now then, and we'll have to get public comment here in a minute, but what I'm hearing from the committee is it's automatically given. We're canceling the April meeting and we're canceling the July meeting.
And just for edification, Easter Sunday is April 1st, so you're going to have vacations back the week before and the week after, probably for some people.
Does the committee foresee issues with that? Okay, thank you. Do I have any comments from the public regarding this item on the frequency? So, okay, seeing none. Let's go ahead and move forward then to item 11. This is the time where public has the opportunity to come up and step to the microphone and talk about items that they would like to see the Bureau consider at future advisory committee meetings. Seeing none? No. Then let's move on to item 12. This is now where we go roundtable. Frank, for you, the newbie, we just start from this end and go around to from there. Just, is there any particular item or issue that you would like the Bureau to consider for a future agenda item? Start with Eli.
No, thank you.
Not at this time.
For me, perhaps a discussion, and perhaps it's brief, on when a security officer's license is suspended, how an employer is notified of that. For example, with DMV, when any security officer's license is suspended, if you enroll in poll notice, it automatically notifies you. As I understand it, with BSIS, if a security officer's license is proposed to have action taken, it's part of that disciplinary process. Their name appears, but there's no immediate notification of the action taken, so that officer could continue to work.
We've talked about this in a prior meeting, I believe, or I may be getting mixed up. I don't know if I'm allowed to respond since it's not agendized, but there's a really quick way of how they know. So we'll note it for an agenda, for the next agenda. Actually, we'll just automatically, consider it.
I have nothing, thank you.
As stated earlier, what I would like to have, at least for consideration, is ways that we could, myself, not speaking for the committee, could be helpful in helping to alleviate or support the work of the Bureau, specifically around renewals and guard card applications.
And so for point of clarification is what you can do to help. So
Yes.
you're not sending people over to.
Yeah,
You
no,
know,
what I can do to help.
I'm just
yeah.
kidding. No, what you mean is that we're getting the word out on reducing deficiencies and all
Yes.
that there. Okay.
I have nothing.
Nothing other than what we've talked about.
And I'm assuming that the firearm training manual will probably be discussed as a follow-up. Maybe would like to hear about the Bureau's position on digital licensing. Security obviously are required to carry either a printout from the website as a temporary license until they get their actual license. Would they consider if they have a picture of the license on their phone as a valid license too? That's all.
So basically you're saying in lieu of an actual printout of the license, that they're able to display it on the phone?
Right.
Oh, okay.
I have a question on that. I'm sorry. That's a great question. I know that for guard cars, that's permissible, but I think that it would be at least similar or the same for what you're referencing, I would think.
For what now?
For what he's referencing, like having a digital photo of the registration or the process.
So basically it's just pulling up the website and saying, here I am.
Yeah.
Just to add on that, one of the challenges is just lost or washed cards or damaged cards. The process to get a new one is challenging. That
So you're talking about a replacement.
Placements, right? Which
We're working on updating forms on that. So, but that actually would be maybe a really good opportunity to talk about it. And the form, all that is part of what we talked about earlier here during my update, which is the nexus is how can we improve efficiencies and effectiveness in our business processes. DB?
Nothing for me at this time, thank you.
Nothing for me, thank you.
nothing more for me.
I think maybe come the October meeting, we should revisit the number of meetings per year and talk about it going forward in 2019.
And well, I really appreciate everybody's feedback, and I also, speaking on behalf of the Bureau and the staff, greatly appreciate your recognizing and being sensitive that this is going to be challenging couple of months, and that giving the Bureau the opportunity to focus on those efforts. So thank you. We are now on, we're on item 13, adjournment. Do I have a motion?
Second.
So call the roll. Anton moved and Roy seconded.
Alrighty. Simon Cruz.
Aye.
Simon Cruz, aye. Marcel Egley.
Aye.
Marcel, aye. Anton Farnby. Anton Farnby, aye. Frank Huntington.
Aye.
Frank Huntington, aye. Todd Inglis.
Aye.
Todd Inglis, aye. Matthew Lujan.
Aye.
Matthew Lujan, aye. Lynn Morfeld.
Aye.
Lynn Morfeld, aye. Nancy Murish.
Aye.
Nancy Murish, aye. Eli Owen.
Aye.
Eli Owen, aye. Stanton Perez.
Aye.
Stanton Perez, aye. Roy Ron. Roy Ron, aye. Tim Westfall.
Aye.
Tim Westfall, aye. Motion passes with 12 votes.
Let the record show that the meeting adjourned at 1:56 p.m.